You're watching The Court Report, and I'm Greg King. When you create something original, the idea of a patent is to protect it from being copied. And yet in an industry rife with illegal copying and downloading, New Zealand doesn't allow computer software to be patented. On the face of it, that seems mad. And some software developers have been battling for years to change that. But there seems to be just as many against the idea. Why the conflict? Joining me now, intellectual property expert from Chapman Tripp, Matt Sumter, and alongside him, software developer and director of his own company, Don Christie. So gentlemen, thank you both very much for joining me. Matt, let's start by explaining what's the difference between a patent and a copyright.
Sure. Patent and copyright are two branches of intellectual property law, and they protect different endeavours. Patents protect ideas, inventive ideas, world firsts, if you like, and copyright protects original expression, principally things like books and art and painting and all the rest of it, but famously the instructions for the use of a new weed killer protected by copyright. But the expression of things. Patents, all about inventions, inventive ideas.
The Act for Patents, of course, goes back to 1953.
The current New Zealand patent regime is based on a 1949 UK statute. It's massively out of date, and we're in the process at the moment, and we've been in this process for the last decade or so of reforming New Zealand patent law. As the law currently stands in New Zealand, and as the law has stood since the early 1990s, you can secure a patent for computer software. Computer software is also protected by copyright. Now, there is this, in my submission, rather mad proposal to exclude computer software from the patent regime.
Don, what's your fix on this? You think copyright protection is sufficient and patents shouldn't be able to be granted?
Yes, absolutely.
Why?
Computer software is a series of mathematical algorithms which traditionally is considered the same as art, music and other creations. In fact, it's similar to sort of legal arguments and structures. So you wouldn't necessarily, for example, want to patent certain legal defences. You know, if the Greg King defence, you know, win-all defence was patented, it would do terrible things to precedents. But also it would mean that people that wanted to use those sort of defensive type ideas and innovations and inventions, if you like, wouldn't be able to use them in law. And we feel that in our industry that computer software is the same as that.
Don, is this a widely held view within the software industry?
Absolutely. I mean, in New Zealand, it's a widely held view of the New Zealand Computer Society, for example, which is our professional body, of the New Zealand Software Association. It's a widely held view, it's a view of our largest software exporter, for example, Orion Health. Ian McRae's got a great phrase that basically patents are worthless. The only way to be successful is to innovate and innovate fast. And he's exactly right. And that's been the way our industry has worked, you know. We've been the fastest.
But you could say the same thing about the car industry.
Well, the car, no, you couldn't. And I'll tell you about the difference between developing software and developing a physical mechanical object, is that developing software is literally like writing a book or creating music. You're sitting there typing out hundreds and hundreds of lines of mathematical algorithms every single day. Each one of those concepts is, under, you know, Matt's kind of idea, patentable. For example, if you press a button to load up a new page on your internet browser, you'll probably run dozens of programs on your own computer to do that. You'll probably run dozens of programs going down the internet wire onto the servers.
Matt,
and it just needs one person in that flow to say, oh, actually, I've got a patent on this little bit to stop the whole effect working.
Matt, how do we actually go about patenting a mathematical formula?
There are some challenges in there, but I'd just like to address some of the inaccuracies and the suggestion that the entire software industry is behind and supports the idea that there shouldn't be patents available for software inventiveness. That's simply not the case.
I should have said New Zealand software industry.
There's certainly a very significant part of the New Zealand software industry that is very supportive of patents in this industry. The law as it stands in New Zealand is exactly the same as it is in Australia and the US and other major trading partners of ours. What is proposed here is almost a complete ban, or potentially a complete ban, on the patentability of software. In jurisdictions like Europe, where there are some restrictions around the patentability of pure software or software per se, you can still get an invention for software which produces a novel technical effect. Software makes your car run in the rain. Software makes the telephone network run. Software drives navigation systems. It makes hearing aids work. It makes dishwashers work. It does all sorts of things.
And so when you've got a formula which gives a practical outcome, a practical application, the whole thing can be patented,
exactly.
where it's just numbers on a binary numbers on a page, that probably can't be.
Indeed, and that's the law as it stands, and that's the law as it should be going forward. But the proposal is to change it completely.
What do you say to the argument?
Well, there is no doubt that mechanical objects that have a piece of software in them are patentable. That's not the issue. That's not what the Select Committee said. The Select Committee said those objects are patentable, but what the piece of software in those objects that changes its state from A to B isn't.
The competing sides of the argument seem to be this, is that on the one hand, you're saying that attempting to patent this type of technology will have the effect of slowing down progress and evolution.
It has.
And on the other hand, Matt, I suspect your side of the coin is that if you can't patent it, why would you sit up all night researching and preparing this new application if you're going to get nothing out of it except other people are going to use it?
That's exactly right. Patents are a time-limited monopoly that encourage inventiveness and innovation.
What are they, 8 years, is it?
20 years,
20.
But it doesn't...
We didn't have an internet 20 years ago.
It doesn't matter so much in the technology industry because time outstrips the patent monopoly anyway. But
yeah.
it provides inventors with a standstill period, effectively, where they can commercialise and exploit their innovation and make a return on the investment they made up front. Now, the fundamental difficulty in a lot of the conjecture that's coming out of the free and open source software movement is that somehow software is different from other fields of endeavour. It's not. There is no principled basis for distinguishing between software. There's no basis for distinguishing between software and any other inventive endeavour. Why treat software developers like Don any different from electrical engineers, any different from any of the other inventors working with pharmacokinetics or anything else? There's no basis for it.
Matt, we do have copyright, and that does apply in this area. Why isn't that sufficient? Why can't a copyright prevent someone from going out and copying what you've done?
It can to some extent, but copyright only takes you so far, and you have to directly copy the source code which sits under the application. What patents give you is a time-limited monopoly over your inventive functionality, and that's been the case since 1993, and in lots of people's considered judgment should continue to be the case.
The idea that copyright only goes so far, again, is nuts. What copyright allows me as a software developer to do is have a direct relationship with my client, let's say it's you, and I can license you certain rights in the use of that software, and you can pay me for those rights.
And I definitely want to talk to you about this Greg King defence.
Yeah, that's right.
Into it. But I suspect we're not going to solve the issue tonight, but that's the Core Report for another week. Next week is our final show for the season, and we're making it a bumper episode. We'll be in Christchurch at Ngā Hui Wha Marae for a 1-hour special. Be sure to tune in next week, or even better, come along.